So this is joint work with Lev Menand at Columbia Law School. This paper is not directly about sustainability, but it is indirectly about sustainability. You know, Adam Tooze, the financial historian, has taken to speaking about what he calls a polycrisis. I don't know if he coined that term or if he got it from elsewhere, but the idea that we have multiple interacting and reinforcing crises that we're confronting, both as a nation in the U.S. and in the world more broadly. You know, I think our financial and banking problems in the U.S. Have created or amplified and compounded some of our political dysfunction, which in turn makes it much harder to deal with other problems in our society. So I do think these are related topics. In part, this paper is about the history and logic of U.S. banking law. But it is more than that. It's a theory for financial reform that isn't specific to the United States. In fact, I presented this paper last month to the Directorate General for Financial Stability of the EC, and it was a well-received presentation there. And so I'm going to try to focus on not just the U.S. part, but the broader sort of conceptual part. And it draws in part on prior writings. My 2016 book, The Money Problem, and then a more recent textbook on networks, platforms, and utilities, of which my co-author on this paper, Lev Menand, was also one of the 4 co-authors on that book. You know, that book's about, well, networks, platforms, and utilities. And I want to preface my remarks here by asking you to think about banking maybe a little bit differently from how you're accustomed to thinking about it. So I suspect for many of you, if you think about a bank in sort of the most generic terms, we say, well, it's a financial intermediary. It takes deposits, it makes loans, you know, the liabilities here are very short-term or demandable, and therefore sort of run prone. Maybe there's a self-fulfilling dimension to that run behavior, and that's bad for the broader economy. We see recessions come from the banking system, and therefore we need to regulate. It's sort of an externality view of the reason for engaging in bank regulation. It's a sort of particularly unstable form of intermediation. And what I want you to think instead, or in addition, I'm not going to say that's wrong. There's nothing wrong with that conception, but I'd like to add to it what in some ways is, you know, a somewhat more traditional conception of thinking about a bank, which is that it is an engine of money augmentation, and that it does this on behalf of the state. A bank is an agent of the state. A banking charter is an outsourcing arrangement for the issuance of the money supply. And these are not incompatible views, but I want you to keep the latter front and center. And I think there's a couple of things good things that come from this. One is descriptive and one is normative. The descriptive point is that you really cannot understand US banking law without keeping that latter conception front and center. And so it provides a framework for understanding how the pieces of banking law fit together. And the second is normative. I think with the latter conception, this sort of outsourcing or franchising conception of what a bank is, actually expands your vision to an appealing normative framework for thinking about how banking law ought to work. Okay, so I'm going to say a word about, I'm going to start with the US here and say a word about the New Deal system of banking law. The New Deal, of course, is the 1930s, the Franklin Roosevelt administration, but the New Deal system of banking law actually had its roots in the Lincoln administration with the National Bank Act of 1864. And under this framework, banks were governed in many ways as public utilities. Chartering was restrictive. banks were given the exclusive privilege of augmenting the money supply. In other words, we said only banks can do this. Only federally chartered banks were endowed with this privilege. They were separated off from commerce. They were subjected to constraints on their activities and on conglomeration with non-bank enterprises. They were subject to geographic constraints, had something almost akin to a franchise area that they had to serve. Bank money was a government product. And you could think of this in terms of deposit insurance, but even before deposit insurance, U.S. banking law sought to sort of back the money supply, the bank money supply with U.S. Treasury bonds. And the government regulated the quantity of and the interest paid on bank money. So this, I'm suggesting, was a public utility conception of what a bank was. It was an outsourcing arrangement. It was understood to be an outsourcing arrangement for issuing the money supply. Salmon Chase was the Treasury Secretary for President Lincoln, and he was the framer of the National Bank Act, which is really still the core of U.S. banking law. When you study U.S. banking law, you study the National Bank Act. Banks were in effect franchisees of the government. This is a word that is used in our banking laws. They're referred to as franchises of the federal government. And the period during which this system had its heyday also coincided with a golden age in the American economy, and I don't think this was entirely a coincidence. What we saw in the last 4 decades was a degradation of this system, what might be called a collapse of banking law. Liberalization happened along a number of dimensions in terms of bank activities. Geographic constraints, conglomeration. We desupervised a lot of banking activities and changed the nature of the way bank supervision works to be much more process-oriented, less substance-oriented. Money creation, we no longer confined to the banking system, and actually by the eve of the financial crisis of 2008, non-bank deposit alternatives, money substitutes, exceeded deposits by a large margin. We sometimes call that shadow banking, and so on and so forth. And so we combine this liberalization with an open-ended backstop for non-bank money substitutes. So I call this liberalize and backstop. We don't use that phrase in the paper, at least not yet, but I may put it in. So this is essentially what we've done in the last 4 decades, and I think the consequences have been not great. We've seen recurring financial panics, ever expanding too big to fail institutions. We have a monetary financial complex with the Federal Reserve at its center. Loss of monetary control. The Fed no longer controls the money supply. The money supply, in fact, non-bank money substitutes control the Fed. The money markets say jump, and the Fed says how high. This results in rent extraction, upward redistribution, asset price inflation, and all manner of financial assets and non-financial assets, real estate, and so forth. Financialization of the economy. We've written just an unlimited put option behind the U.S. financial system, and what should you expect to happen? You expect growth of that system, unrestrained growth. And I do think this is related to the democratic erosion that we've witnessed in recent times. So there's a widespread sense. There's still a widespread. We had Dodd-Frank in 2010. I worked on Dodd-Frank. I was at the Treasury Department at the time. I helped with both Title I and Title II of Dodd-Frank, but there's a widespread sense that we may have missed the mark, and that structural reform is needed. And so, what does this mean? And our paper offers one vision for this. I'm not going to be able to get through the entire vision in this talk. But I do want to say a few things about it. First of all, I've sometimes been called a radical when it comes to banking, and I have exactly the opposite view. I am the only conservative in this debate in the U.S. And what I mean by that is I'm talking about following through on the New Deal system of money and banking that worked quite well. And what's been radical is this experiment of the past few decades of um, of liberalization and backstopping system. So every element of the system I'm going to describe, and again, I'm not going to get through it all. I'll sort of give you a broad outline. Has an analog or precedent in U.S. banking law. And I think this paper has the benefit of clarifying the logic of the law we already have. It's been degraded to some extent, but the basic bones are still there. But we have to understand the logic of that system in order to improve it. And I've been using the phrase banking law and not FinReg, and that's quite deliberate. There's been a sort of, I think this is in conjunction with the liberalization of recent decades that I spoke about, a tendency to conflate these things or collapse them together. FinReg is a hyper-technical domain, or at least has become that. Banking law is structural and constitutive. It's more than regulation. It's a mode of economic governance, and it's a form of monetary system design. That's what we're doing when we're designing our banking laws, is designing a monetary framework. Okay, with that, I will turn to the structure of the system. I'm not going to get through it all. We'll see how far I do get through it. You know, I gave this presentation to DG FSMA, as I said last month, and they gave me 40 minutes to do it. I tried to boil this down, but I knew I wasn't going to get it down to 15, so I'm just going to do the best I can. It's a little bit like the Mark Twain quote, who said, I didn't have time to write you a short letter, so I wrote you a long letter. I'm feeling that right now. What are the questions that a system of banking law has to answer? Is a place to start. And it needs to define the legal institutional features of money, what entities may legally issue it, how they're chosen or created, under what terms and conditions they operate, what the issuer's relationship is to the state, how aggregate monetary control is exercised, and the mechanics of money transfer. And so Lev and I in the paper outline the system. And again, this is really just sort of following through on an evolutionary step forward from the system of New Deal banking law that we had in the United States that worked really quite well for many, many decades. And the system components fall into 4 categories. We describe what member banks are in the system, how their role in economic governance is the second point, ownership and control of member banks is the third point, and their duties to the public is the fourth point. I want to say, when we talk about banking, and maybe I need to, I find that I need to clarify this point often. When we speak of banks as public utility, we're not talking about finance as public utility or lending as a public utility, right? We're not talking about restricting entry into those activities. Finance is a much bigger place. I mean, even in the U.S., banks are responsible for only about a third of lending activity, about 18% of total credit extension. So they are participants. They're essentially price takers in the lending markets. And we don't see that world changing at all. We're not talking about restricting entry into lending or regulating rates in the lending markets. We're talking about the money augmentation function of the banking system, which is really what defines what a bank is. And so I only have about a minute left. So which raises the question what I ought to do. I think I'm going to, I think I'm just going to skip to the end. So I've shown you here, this is the system components, and I haven't told you exactly how they all work. I guess you'll have to wait and read the paper to see that. Again, this is not a talk that is one that I'm able to condense effectively into 15 minutes. So I'm gonna move to the last. I'm going to move to the last. I'm just going to say a word about unauthorized banking. And this is the last part of the talk. And sometimes the most controversial part of the proposal. One of the things that Lev and I argue, and that I've argued in other work, is that non-bank money substitutes are a big problem. The first law of banking, as I call it, has always been, really since the creation of the Bank of England, is to say these banks have powers to augment the money supply, and other enterprises should not be doing that, right? So the first law of banking is a law that applies not to banks, but to everyone else. It's a generalized prohibition. And it exists in US banking law even today. Here's the unauthorized banking provision in the US code. It's 12 U.S.C. 378A2. It's unlawful for any person or firm, ... to maintain deposit liabilities without a banking charter. That's basically what this says. It doesn't say it that well, but this has been on the books for over a century. You need to have a banking charter to have deposit liabilities. We all understand the deposits are money. This is sort of a Econ 101 point. The legal problem here is that we don't define what a deposit is. There is a definition of deposit in U.S. federal law, but it defines a deposit as a liability of a bank. And here we define a bank as that which has deposit liabilities. So we're in a perfect legal circle, right? And think about how different this is from other domains that we study as business lawyers, right? I mean, you spend the first 3 weeks of your sec grade class. What is a security? And there's all sorts of gray areas. And there's a whole case law, there's a canon around this, but you recognize that you have to start, that's your starting point before you can actually talk sensibly about securities regulation. We don't do that for what constitutes a monetary instrument. And this to me is the original sin of banking law, that we don't do this with any of the same functional approach that we use in a lot of other domains. And so I know that I'm out of time here. The unauthorized banking provision that Lev and I are proposing here would require legally defining what constitutes a monetary instrument in functional terms. Basically, this is demandable or short-term debt, dollar denominated, demandable or short-term debt, at least in the US, dollar denominated. Things like repo, euro dollars, and money fund shares would be key examples of things that constitute monetary instruments but do not qualify as deposits under current law. And the basic first requirement of structural reform of the banking system is to revisit this definition. That means, I want to be clear about what that means. If you don't have a banking charter, you need to term out your funding. You need to fund yourself in the capital markets and not the money markets. That's what we are suggesting. I think this is sort of the first and necessary step to restoring a sensible and workable banking system. I will stop there. Thanks.